It's the appointed time and we have a quorum. Will the Secretariat please invite the government officials to come in? Welcome, representatives from government departments. Undersecretary for Health, Dr. Cecilia Fan. It is your first time attending the subcommittee's meeting. Welcome. Mr. Leo Lee, Principal Assistant Secretary. Ms. Amy Low, Assistant Secretary. Dr. Adi Chan, Principal Medical and Health Officer of the Department of Health. Mr. Billy Yip, Secretary of the Council on Human Reproductive Technology. Ms. Vonda Lam, Senior Government Counsel of the DOJ. Ms. Janice Leung, Government Counsel. Welcome. On the 25th of July this year, the House Committee agreed to establish a subcommittee to study two pieces of subsidiary legislation in relation to human reproductive technology. There are Human Reproductive Technology Licensing Amendment Regulation 2025 and Human Reproductive Technology Ordinance Amendment of Schedule 2 Notice 2025. The paper has been sent to members. First of all, we have to deal with the issue on whether we should invite the public to make submission. Ms. Chen, Chairperson, I think there is not a lot of disputes in society concerning the matter, but I think it is always best to make available a platform to receive written submissions. The proposed amendments are technical. There are some changes in policy matters, but it is not very controversial. So the other members agreed that we don't have to conduct a public hearing, but rather invite public submissions via written form only. Thank you. Now we move on to the legislation itself. We will now invite the government officials to walk us through the contents. Chairperson, the two amendments are in relation to implement the recommendations made by the Council on Human Reproductive Technology to cancel the statutory storage limit for gametes and embryos for own use, and also updates the list of sex-linked genetic diseases, which justify sex selection. Now, the government has reviewed the code of practice on reproductive technology and embryo research between 2021 and 2024. Stakeholders' views have been collected. After research, the Council proposed some amendments. Now, I will brief members on the major contents of the amendments. Now, currently, under Section 15(2) of the regulation, gametes or embryos for own use can generally be stored for at most 10 years. For patients who may be rendered infertile as a result of treatment, their embryos can be stored for 10 years, and therefore gametes for own use is 10 years or until the patient reaches 55 years of age. The current statutory storage periods of gametes embryos for own use are based on discussion in the 1990s. With scientific developments, it is proven that the duration of storing gametes or embryos per se has not been established as a major factor affecting their safety or quality. And also, under the Ordinance, there is no upper age limit for conducting reproductive technology procedures. If we set a standardized storage period for gametes and embryos based on the medical risk of pregnancy at an advanced maternal age, that is not the most appropriate approach. So having studied the relevant legislations in other jurisdictions and consolidated considerations from various aspects, including medical, ethical, and social factors, the Council considers that members of the public, given that they are adequately informed of the medical risk and impacts of delayed childbearing, they should make their own decisions on the storage duration of their gametes or embryos. So whether or not there are medical reasons, patients will be allowed to store their gametes or embryos for at most 10 years. Now, according to Section 15, Bracket 3 of the Ordinance, no person shall, by means of a reproductive technology procedure, cause the sex of an embryo to be selected, whether directly or indirectly, except when the purpose of such selection is to avoid a sex-linked genetic disease specified in Schedule 2. Now, the Working Group on New Developments in Reproductive Technology under the Council, comprising obstetricians and gynecologists, medical geneticists, and members of the public, has proposed the following amendments. Having considered the international authoritative databases on genetic diseases. So the amendments are set out in the Human Reproductive Technology Ordinance Amendments of Schedule 2 Notice 2025. These are relatively technical amendments. The two pieces of subsidiary legislation, subject to the approval of the legislature by negative writing procedure, will come into effect on the 1st of December 2025. The Council will also amend the Code of Practice to implement the regulations on the same day. Now, the amendments will enhance the regulation on reproductive technology and also give more liberty to patients. I hope members would support the amendments. Thank you. The floor is now open. We don't have a lot of attendees. I will give each member 5 minutes. Ms. Lam So Wai, Julie Chan, Edmund Wong, and myself. Ms. Connie Lam, 5 minutes. First of all, thank you, Dr. Fan, for attending your first LegCo meeting. Now, I welcome the cancellation of maximum storage period for gametes and embryos. We have a lot of professional women nowadays. Their marriage age has been delayed, so I welcome this change. I have some questions for the administration. According to the paper, there are more scientific evidence showing that the duration of storing gametes or embryos has not been established as a major factor that affects their safety or quality. So are there any empirical studies, research showing this fact? Are there examples in other jurisdictions? Now, for Asian societies, if patients take out their frozen embryos, say in 20 years' time, can the egg still be fertilized? Do we have sufficient storage facilities in Hong Kong? And also the usage rates and vacancy rates for facilities for storing gametes and embryos. What are they in Hong Kong? Now, about sex selection, what is the number of patients with sex-linked genetic diseases which justify sex selection? And also, there will be deletion of 15 conditions for reasons that they have no significant impacts on health. So why were they included on the list in the first place? Undersecretary. Concerning whether there are places in the world with proven research showing that removing the storage limits for gametes and embryo is safe, I would defer to the hospital authority. Now, for sex selection, I will also defer this question to my team. Concerning usage rates and vacancy rates, which facility was the member referring to? I meant facilities for storing gametes and embryos. For example, those facilities for freezing eggs. is very high vacancy rates in Hong Kong. I will also defer to my team from the Department of Health concerning the number of licensees with valid licenses. Which official? How many licensees are there? And after removing the storage limits, do these organizations have the facilities to store the gametes or embryos for such a long time? And what about examples from other places? Department of Health or the Health Bureau? Thank you, Chairperson, and thank you, Ms. Lam. Concerning foreign examples, many foreign countries have removed the maximum storage limit for embryos and gametes. That's the same for the mainland and also for the US and Singapore, which is also an Asian society. So for Singapore, the storage limit is 55 years. So if you store your eggs at the age of 20, you can still take out the eggs at the age of 75. Now, according to empirical data, the quality of the embryo would remain at the time when the egg is frozen. So that's scientifically proven. Of course, the older the patient is, the higher the risk is of pregnancy, as well as the quality of the eggs. In terms of sex selection, starting from the August of 2027, when the regulation was implemented, only one patient has resorted to sex selection. Now, science has progressed a lot nowadays. If patients are worried about sex-linked genetic diseases, they can adopt prenatal methods to treat the condition. So actually, with a prenatal blood test, the patients can test whether the embryo is affected by genetic disease. Yes, and also, prenatal is already sufficient. Now, the regulation is just a backup measure. The need is not that great. We're still keeping the regulation in place because there is always a chance that the results would be missed during the prenatal test. Now, if a couple consults a doctor as the hospital authority, let's say if the couple has some genetic disease so that they can't give birth to a healthy male, can they opt to give birth to a female instead under the regulation? Now, actually, we have updated the list according to an authoritative institution, that is Harvard University. Now, there are also some other sex-linked diseases, but it is not so serious that it would affect the choice of gender. Those diseases are not extremely serious with dire consequences. So when forming the list, we have considered the authoritative list of Harvard. And there are hidden and there are some hidden diseases. So I would defer to the doctor from the HA to explain.
Thank you. Well, we'll have to ask the next member to speak. If need be, please supplement later on. Ms. Judy Chan. Thank you. Welcome, Dr. Fan, for coming to our meeting today. It's not about an ordinance, but it's an amendment to the regulation. Our party has been concerned about this policy for a long time in relation to egg freezing time limit. We made proposals in the past few years as well. The birth rate in Hong Kong has been quite low. We need to encourage more people to have children using different methods. Indeed, the storage period of 10 years gives families with infertile couples quite a lot of stress or pressure. For the consultation period, it lasted from 2021 to 2024. It's quite a long time. In these 3 years, how was the consultation? I understand you have covered quite some areas, such as medical, ethical, and social factors. In relation to Section 45, brackets 2, you mentioned a gamete or embryo for own use. By the phrase for own use, is there any limitation in relation to where the embryo or the gamete will be used? As I understand, if they are for own use in overseas jurisdictions, some may want to receive treatment overseas. Does the existing ordinance allow this method? Are the applications complicated? My next question is about policies, not about technical. As I understand, you mentioned preventing them from having unreasonable expectations and missing the optimal time of childbearing. I cannot say this is negative, but in the future, when it comes to public education, can you do it the other way around? Say, after relaxation of the requirements, you will instead encourage more women to plan for their future. They may choose to freeze their eggs earlier. They don't necessarily have to wait until the very end of the period before they will make a decision to freeze their eggs. I hope you will adopt a more positive note when it comes to public education. Understand? Thank you. I do agree with member. It's about how we express it. We'll think more about the perspective of members of the public. We are rolling out a good policy. We do need to think from the perspective of the public. I go along with member. I do understand. Thank you. In relation to whether we will import embryos from outside Hong Kong, we have a code of practice. We actually allow gametes and embryos to be stored after importation into Hong Kong. Wherever they are stored, including those outside Hong Kong, the storage period starts when the storage starts. As long as other specified conditions are met, embryos and gametes can be imported into Hong Kong for continuous storage. What about the gametes or embryos are extracted in Hong Kong? Can couples carry on with IVF outside Hong Kong? Well, existing laws allow this. Gametes and embryos are allowed to be exported from Hong Kong. That is allowed by current legislation. Well, are the procedures cumbersome? Can you walk us through the procedures? I will have to ask the DOH to explain. What about any cases? There were about 90 exported cases between 2021 and 2023. Thank you. Next member, Mr. Edmund Wong. Thank you, Madam Chair. I have only one question. The storage period, as I see, will be gone. But there is still anonymous donation. I'd like to know why there is still a storage period of 10 years when it comes to anonymous donation. Can one choose to keep the gamete for her own use? In this case, will the time limit be removed? Dr. Fan, thank you. For donated gametes or embryos, they could be donated by way of, under an anonymous donation or designated donation. Based on our practice or experience, for gametes or embryos donated under an anonymous donation, the supply is limited, but the demand is great. That's why within 10 years, more often than not, all the gametes or embryos will be gone, or the gametes will successfully lead to 3 embryos. That's why they could no longer be stored. That's why there is no need to relax the arrangements. The existing practice is reasonable and appropriate. A gamete or embryo can also be donated under a designated donation. According to existing practice, one can make an application 2 years before, and that will lead to another live birth. Under the existing legislation, whether couples can try live births once again, and we have already taken into account these factors. Thank you. Well, just now the administration said demand outstrips supply. That's why the gametes have been used up in 10 years. That is based on the administration's experience, but we need to ensure consistency when it comes to legislation. We need to ensure consistency between anonymous donation and designated donation. We cannot say that we're not going to move any amendment just because, based on our experience, those gametes will be used up. Is there any reason why there is still a time limit in the case of anonymous donation? Thank you. When gametes and embryos are kept for own use, we take into account safety and the needs of society. Apart from medical factors, there are also ethical and social factors at play. We need to take into account the well-being of children as well. All these are factors that we take into account. When it comes to gametes, they lead to 3 live births. Afterwards, they could no longer be used. That is our practice as well as overseas practice. The Council on Human Reproductive Technology has discussed this matter, and it is decided that this practice will be kept. However, the Council will keep reviewing the situation, and they will also take into account different feedback, views, before they proceed with another review. Thank you. I will let another member speak first. Thank you. Madam Chair, well, it's my turn. I myself used human reproductive technologies to have my own child as well. As I understand, the storage rate and the usage rate are on the low side. Can you tell us more about the figures? Can you tell us the breakdown of donation and for own use? Regarding storage facilities, there has been relaxation such that there will be no time limit. Do we have sufficient facilities? Do we have sufficient equipment? How many licensing units do we have? Do we have sufficient equipment and facilities to store these eggs? Thank you. Underside, we have some figures in 2024. there are a total of 26,878 frozen eggs in licensed centers. However, there were only 47 embryos produced with frozen eggs. Only 7 cases have ultimately led to ongoing pregnancy. For the figures in relation to live birth events, the figures were between 5 and 7. Just now, you said that in relation to donation, the demand is quite high. Do you have 2 sets of figures, one for own use, the other for donation? Thank you. For licensed centers, in 2024, for sperm donation, 133, and for eggs, 43, embryos, 2. Regarding donation, well, as far as I understand, when these are stored for 5 years, the rate will drop to 10%, which means when it is appropriate to use a certain gamete or embryo, then immediately it will be used. Seldom do we see gametes or embryos being kept for a long time. The secretary said it's not ethical to do so. Sometimes an elder sister donates gametes to her younger sister, and of course in these cases the gametes will be used very quickly. In the case of donations, say family members, usually they will continue with the procedures very quickly. There is a time limit of 2 years. In other words, when there is no rush, they will proceed with the first try as well. Proceed to the first try first. Then probably in the second attempt, there will be a live birth event already. Just now, probably I use some technical terms. But overall, the supply is on the low side, but the demand is on the high side. Well, what about licensed organizations? There are a total of 36 licenses, among which there were 2 types of license centers, 18 of which are about IUI. Well, there are a total of 12 private licenses and 6 in the public sector. In relation to fees, I may provide more information later on. Each time, at the time of renewal licenses, they will have to pay a certain amount of fee. That is about 6,000 or so. The period may last from 1 year to 3 years. They only need to pay the costs at the time of renewal. Next member, Ms. Nick Zealand. Thank you. I'm glad to see that we can finally work on this amendment. I'm glad to see that the Bureau made this announcement on the 13th of March. It was actually my birthday. I was glad to learn more about this on my birthday. I had some sort of bickerings. I had some sort of bickerings with the secretary. Well, my husband didn't want to continue with this, but anyway, well, I'd like to say that it's about life planning. In Hong Kong, A lot of young people are career-based. Say women, some of them are iron ladies. It's difficult to ask a lady to give birth to a baby at 20 odd years old. I'm glad that the administration has taken into account the views of the public and made adjustments to policies. I'd like to ask about the transitional period. I learned about this piece of news in March, and it will come into operation in December. Some doctors or some people asked me, this piece of legislation will only come into operation on the 1st of December. Are you going to provide any grace period? Some may have to send the gametes or eggs to other places, and it's not at all easy to do so. You cannot just call up a doctor and make this happen. You will have to contact you may have to contact DHL to make arrangements. From the 13th of March to the 1st of December, is it possible to keep gametes and embryos so that they won't have to be damaged? That is my first question. Second question, what about the person who stores the gamete or embryo passes away? When one passes away, can the gamete or embryo still be used? Well, after the passing of the person concerned, will the gamete or embryo be damaged right away? Mr. Eman Wong's question hasn't been answered either. When there is no time limit, there may be more people willing to donate gametes. $10 later, can I change the anonymous donation to my own so that I can go on to use?
Under Secretary, thank you, Ms. Lam, for your questions. Now, after a storage period of 10 years, the amendments will take effect on the 1st of December. So according to existing requirements, after 10 years' time, the patients will have to agree upon a arrangement with the storage institution. Now, the law is not retrospective. So according to existing practice, the storage has to be terminated. Now, according to past figures, there are only very few cases where gametes, especially embryos or eggs, would be stored as long as 10 years. That accounts for only less than 10% of the total cases. Now, that's even more true in recent months. But we understand for a minority of patients, having a longer storage period is important. Now, other places like Singapore, the US, and the mainland do not have a storage period. So that's why we are proposing the amendments. For the cases where the owner of the gametes or embryos have passed away, according to existing ordinance, the spouse of the patient cannot use the remaining gametes or embryo to give birth to a child. So when the person in question has passed away or is incapable of changing the will, then we will adhere to the original practice. What about my third question? And also Mr. Edmund Wong's question. Now, after donation, the donator cannot claim back the gametes or embryo for own use. Now, according to the Code of Practice, when donating the gametes or embryo, the donator has to sign an agreement. It would specify that the gametes or embryos would be passed on to the licensed body for usage, so the donator cannot take back the gametes for their own use. Next. Sorry, Mr. Michael Lee, you are first. Now I support the amendment. You are lifting the storage period of 10 years. So some may be worried that this move would encourage late childbirth. So education on childbirth is important. Is there a recommended golden period for storing the embryos or gametes? Under 30 or in the 20s? And also, is there a positive direction to encourage the developments of the reproductive industry? Now, about the unlimited period of storage. Now, the storage period is indefinite. However, later in age, the quality of the embryo or gametes would deteriorate. So what if someone has passed away or emigrated? What will happen to the gametes or embryos? Can the offspring of the owner of the gametes or embryo use the material to give birth? Under Secretary, now before storing gametes or embryos, the patient must understand clearly the risks pertained. So despite the indefinite period of storage, there will be specified measures under the Code of Practice. For example, after 5 years of storage, the storage facility should provide additional counseling services to the patients, and only when there is a written consent from the patients can the storage period be extended, and only 2 years at a time. Now, the information to be provided by the patients should include the lower success rates of childbirth with high age, and also the risk of old age pregnancy, and also the potential impacts on the fetus, so that the patients can consider their own marital status and the age and the health status to make a decision. And also the consent form should specify that should acknowledge that the patient has understood the information. So these will all be set out in the Code of Practice along with the amendments. In terms of public education, at Maternal and Children Health Center, there is prenatal service available. The prenatal blood test as well as nutrition test will be offered to potential mothers. So we will make use of the opportunity to educate potential mothers about the benefits of early pregnancy, and that there would be a lower success rate of childbirth at older age. Now, these information will be conveyed clearly to the public concerning patients who has passed away. When deciding to store the gametes or embryos, they will be told clearly that when the patient can no longer offer directions, the embryos or gametes would be handled according to the pre-agreed arrangement. Dr. Chen, please elaborate. Say a couple has stored their gametes or embryos in licensed center. Now, after divorce, the gametes or embryos will no longer be stored. But if one of the spouses decide to keep on storing the gametes or embryos, and upon agreement by the other party, they can still store the gametes or embryos for use. Will there be a maximum number of gametes or embryos to be stored each year? And would you give consideration to the health of patients? Would these conditions be specified in the code of practice? Now, for gametes or embryos donated, now besides success rates and the morality, these are the major considerations. Now, every gamete can give birth to one live birth, but there is the chance that there can be couplets or duplets. Has she answered your question? Please ask your question again. Now, if the patients would like to store the gametes or embryo, how many times can the patients offer their gametes or embryos for storage? For the public health sector, there are some limitations or restrictions. I will defer to the HA. Thank you. Now, whether it is gamete or embryo, when they are extracted, some medical procedures are involved and there is risk. We would recommend that after one IVS and when the embryos are fertilized, then that's fine. But we would recommend the patients to use up all the stored gametes or embryos before storing new ones. So normally speaking, we will not accede to patients' request to store more and more gametes or embryos, except for exceptional circumstances. For example, cancer patients, especially female cancer patients. So for these exceptional cases, we would exercise discretion to store a large number of embryos or gametes. Has your question been answered? Dr. Frankie Ngan. Thank you, Chair. Now, a simple question. According to your estimation, what will be the impact on birth rates in Hong Kong after the change? Would there be positive or negative impact, or how many newborn babies do you expect to be added by the policy change? Under Secretary, have you made such an estimation? Now, the major premise of the amendment is for patients to exercise their reproductive autonomy. Now, with higher age, with advanced maternal age, there is higher risk to childbirth and pregnancy. That fact hasn't changed. But as other members have mentioned, this is a need of modern women, so we want to offer reproductive autonomy to women. But we do not encourage delaying childbirth because that would reduce the success rate and give rise to high risk.
Yes, I do understand. We aren't encouraging delayed childbirth, but the overall impact should be positive. Will the government conduct any assessment? Will it boost the birth rate in Hong Kong? Or probably not much of an impact on the birth rate? What is the administration's assessment? Undersecretary. Well, now, for human reproductive technology or assistive reproductive technology, they account for about 5 to 6% every year of all the childbirths in Hong Kong. I agree with member. We'll keep monitoring the situation. In the past 5 years, we can see that the figures are about 5 to 6%. That is for those giving birth to a child using assistive reproductive technology. Yes, that is the case. So you will keep an eye on the situation, is that right? Yes, thank you. Now my turn. I'd like to follow up on the question asked by Ms. Judy Chan. In the paper, the Council on Human Reproductive Technology says that to ensure that members of the public are fully informed of the associated medical risks and the trade-off involved, the purpose is to prevent them from having unreasonable expectations and missing the optimal time of childbearing. Well, in the past, some people wrote to the South China Morning Post saying that this shouldn't be done. That is because these more flexible arrangements would cause some women to delay marriage or delay childbearing. Do you have any actual figures proving this? Or say 5 years, the figures only stood at 5 to 6%, then it doesn't seem to be this case. I mean, with this improved flexibility, no people delay their marriage or childbearing decisions. Well, according to figures we have, the purpose of the delay, as I mentioned, is to allow people to better realize reproductive autonomy instead of dragging their feet. Every year, the figures stand at 5 to 6 years, as I said. We'll keep monitoring the situation to see if there is any increase in this figure. But this is not encouraging people to delay their marriage or childbearing decisions. I can quote a document. "13,000 people freeze their eggs not on medical grounds. A total of 27 research projects were involved, and the median was 7 years, but only 10% of the people used the eggs that they had frozen. International figures show us even if the storage period of freezing eggs could be longer or could be made longer, it doesn't mean that people will drag their feet or delay their childbearing decisions. As I understand, only a wedded couple could do so. Is that correct? Well, for embryo, yes, only wedded couples could do so. For IVF or IUI, yes, indeed, only wedded couples can do so. What about gametes? Not necessarily a wedded couple. That's right. In the mainland, in the US, there is no time limit, as you said just now. You also said that you want to allow people to better realize their reproductive autonomy. Have you considered allowing single women to store or to freeze their eggs first when they are still at a young age? Just now you said it's not as good when they freeze their eggs when they grow older. So what about allowing women to freeze their eggs in their 20s? Well, at present, there is no restriction. Women can choose to freeze their eggs for own use. However, there are restrictions when it comes to embryos. In accordance with legislation or in accordance with the Human Reproductive Technology Ordinance Cap 561, it is only limited to a wedded couple. In other words, there is no time limit when a single woman wants to store her own eggs or gametes. Yes, that is the case. The restriction only applies to embryos. We want more people to benefit from this arrangement. For IVF, yes, indeed, then we have this restriction. Thank you. Next member, Ms. Nick Z. Lam. Thank you, Madam Chair. I'd like to follow up on my previous question. What about when someone passes away under agreement? Can one decide how to choose the way of handling the gametes or embryos? Well, as long as it doesn't happen in Hong Kong, then we don't have to abide by the regulations. Is that right? Say, if one passes away, can the thing being stored be sent out of Hong Kong? Then, something not allowed in Hong Kong may be proceeded with. Is that correct? When someone passes away, she probably has said that the eggs would be handled by my family members. Then could the eggs concerned be sent out of Hong Kong to an overseas jurisdiction for further handling? My next question, for stored embryos, when a wedded couple has divorced, what about this case? Well, when I did IVF, I didn't sign any papers. So do we need to sign these papers in order to set out clearly the responsibilities? There aren't any papers in relation to after divorce arrangements. Just now you said that there is no figure pointing to any delay in childbearing. Well, if there is no such figure, probably you don't want to use this expression. You should quote this only when you have figures to back up your argument. Thank you. Under Secretary, when one passes away or when one divorces, in accordance with the existing COP Code of Practice, the gametes or embryos stored, well, couldn't be used to give birth to a child born after someone passes away. Say donation to infertile couple for medical research, for quality assurance, for training, one will have to clearly specify. For embryos, only wedded couples could choose to handle this. Well, I'd like to defer to my colleague to explain the consent form. Speaker's mic not on. Speaker's mic not on. Thank you. As the Undersecretary said just now, before someone starts human reproductive technology, one would be asked to sign a consent form. This involves the way of handling gametes or embryos when one party passes away. When one passes away or divorces, then gametes or embryos will be handled in the specified manner. That is the method already agreed upon at the signing of the document. Speaker's mic not on. Speaker's mic not on. Just now in your answer, you talked about 5 different cases. Is this an exhaustive list? The crux of my question is that can someone give her gametes or embryos to probably her mother when that person passes away? Are the 5 methods or cases you mentioned just now an exhaustive list? Can I put it this way? Is it an exhaustive list? In the consent form in the Code of Practice, only the 5 cases were mentioned. If a license center doesn't act on the instruction of patients to handle gametes or embryos, chances are that the license center has already violated the COP. Next member, Mr. Michael Lee. Thank you. I'd like to ask about the best time to use the frozen eggs. Data show it is best to store one's eggs under the age of 35. This will lead to a highly successful live birth event. Say when a woman is healthy within a year, can a woman store 12 eggs in total? Is there any limitation, any upper limit? As the procedures may have an impact on the physical conditions of women. If there is an upper limit in the hospital authority, whereas there is none in the private sector, are there any conflicts? Thank you. Undersecretary. Well, the younger a woman is, the more likely one will successfully have a child or pregnancy. This procedure will be conducted by licensed centers, and I will ask the HA to give you more information. At present, we have regulations. All requirements will have to be met. Say below 40s, there are also other requirements such as marriage, physical conditions, and so on. Well, probably I will have to defer to the HA to tell you more. It's not the case that a woman can conduct this procedure 12 times whenever she wishes it, or whenever she wishes to do so. I'd like to ask my colleague to tell you more about what is in place to help wedded couples. Thank you. Dr. Zhang, in relation to freezing eggs, some data show at least you need 20 eggs before you will have a successful pregnancy. Say one IVF on average 10, then we may conduct IVF twice. When one keeps conducting IVF, say 10 times or 20 times, these medical procedures come with risks. I believe medical doctors will conduct assessments for patients. Any more follow-up, Mr. Michael Lee? Are there any differences between the COP of public hospitals and that in the private sector? Well, there may be a little bit differences. Say, for example, when it comes to age, the older a woman, the less likely there will be a pregnancy. For those below the age of 40, the chance of success will be higher. For those above the age of 40, if they want to do so, they will have to do so at their own cost. And whether a person is suitable to go through IVF, I believe that is a medical decision.
Ms. Judy Chen, I have several follow-up questions. There are 36 licensees at present. Do you have plan to issue more licenses? Is there an upper limit for license? And are there applications ongoing? Now, let me give you a scenario. A couple has stored gametes with a facility. Subsequently, the husband passes away because of accident. So will the widow be given discretion to use the gametes to give birth? In March and April this year, we have conducted a widespread consultation. Many storage facilities have submitted their views. Now there are worries. We have asked them whether they would worry about the storage spaces after the relaxation, but there is no such worry in the trade. So the licensees are not worried that there will be a long queue waiting for gamete storage after the relaxation of the rules. Now for the public sector, the eligibility criteria include marriage, both spouses are of a certain age, and also there are no contradicting indications for gamete storage. And also whether the uterus is in such a shape for embryo extraction, and also whether the patients can receive free cycle of external fertilization. And also the doctors would consider the reasons for infertility and also the past record. Now my question is about discretion. Is there a discretionary arrangement in place? I would defer to the Department of Health. Thank you. Now, as mentioned by the Undersecretary, posthumous child is not allowed by the law. Now, I understand, but there are many ordinances specifying discretionary power given to the Secretary. So can you consider including this discretionary power as well? Well, that involves non-medical factors, including social acceptance and so on. This is not about technology or science. It depends whether there is a consensus in society. But there must be a person who can make a final decision. If the treatment procedure has started, the patients can continue. However, according to existing law, if it is not the case, then gamete storage is not allowed for those cases. So in other words, there is no discretionary power. Ms. Connie Lam. Thank you. Now, for patients who have received assisted reproductive treatment, in my previous question, I asked the Undersecretary how many patients were allowed to choose the sex of their babies according to medical reasons. So you have deleted 15 conditions and claim that there is no significant impact on health. But why were these 15 conditions on the list in the first place? Now, in the HA, there is a specialist clinic for couples in fertile age to store their gametes or embryos. So after the relaxation of the rules, will you extend the scope of this service and add more quota places? At present, there are already queues already. In the future, will there be longer queues? And how many clusters among the 7 clusters are offering such services? Undersecretary, concerning the number of patients using sex selection services, according to the figures since 2007, when the Code of Practice was implemented, in 2009, 2 cases were handled by the HA from 1 patient. 2029, oh, you meant 2009. Yes, so the number is extremely low. Second question, we have updated the list of sex-linked genetic diseases. Now, the list is formulated by experts. Still, we will continue to update the list according to the trend. Now, previously on the list, there were some hidden sex-linked genetic diseases. In this exercise, we have updated the list according to the most authoritative authorities. And we found that there are some duplications on the list. For example, if there is a genome in the chromosome and there is one gene which is flawed, however, there is a wide spectrum pertaining to the disease, so there may be different expressions of the disease. So that's why we are integrating the same disease under the same spectrum. And also for other diseases, if we allow sex selection for these diseases, that means that the baby will not be born because of the sex selection. If it is serious, if the disease is serious, which would affect the children's life or future, then we will keep them on the list. The concerning of hospital authorities' service for a couple to receive assisted reproductive services in the HA, what is the current waiting time, and will there be more quota places in the future? Under the HA, there are 9 there are 9 types of services available at specialist clinics. For AR-capable hospitals, there are Princess Margaret Hospital and Prince of Wales Hospital. and also Kwong-Wah Hospital. The quota is 1,100. We will expand the quota to 1,800. 100 more will be added in the first year, and then 300 the next year, and then 100 more each year. The waiting time will be shortened. At present, for patients after receiving the first consultation, the waiting time is 3 to 7 months long. After enhancing the quota, we hope that the waiting time will be shortened. Mr. Edmund Wong. Thank you, Chair. Now, the administration referred to the code of practice on numerous occasions, but do both the private and public health sector have to follow the code of practice? Is it a promulgated code of practice by the government? Yes, all public and private health institutions have to comply with the code of practice. Second question, is the COP legally binding? If it is challenged, does the COP carry legal effect? And will the amendments of the COP require the approval of the Secretary or Director of Health? Yes, may I defer to the Director of Health or Department of Health? According to Section 8 of the Ordinance, the Council has to consult the stakeholders and then set out the code of practice for the code of practice on reproductive technology and embryo research. Now, simply by failing to comply with the code of practice, no one can be prosecuted by the law. However, the Council would consider whether the institution has complied with the code of practice on license application or renewal. So in other words, it is not legally binding. Yes, that's my question. It seems that it is not legally binding. Is our understanding correct? Now, it seems that there are some discrepancies between the Undersecretaries and the Department of Health's explanations. Principal Assistant Secretary. Thank you. Now, there are three components in the regulatory regime. First, our regulation. Today, we are also amending the Schedule 2, that is sex-linked genetic diseases which justify sex selection. So the Council can formulate the regulation. So we are also amending the regulation. For the parts of regulation, we are removing the limitation on storage period for gamete embryos. Now, what about the code of practice? The COP is not a code formulated by the Council which is not legally binding. The COP is part of the Ordinance. But the Ordinance says that the prosecution cannot premise upon failure to comply with the COP. So in terms of whether it is legally binding, according to Section 9 of the Ordinance, I think it's not legally binding because it does not constitute part of the offense. The other rules in the Ordinance can constitute offenses. On the other hand, the COP applies to all public and private health institutions. In practice, all institutions have to comply with the COP as part of the license conditions. Thank you.
I have a follow-up. Thank you, Madam Chair. It's legally binding on licensed centers. It doesn't seem to carry any legal effect. However, when someone passes away or when someone divorces, according to the COP, there is an agreed upon arrangement. According to a consent form of the COP, there is legal binding effect. However, the COP isn't legally binding. Then all of the stuff isn't legally bound. Is it a contract between a patient and a donor? It's not based on law. It is not a regulated activity. Can I see it this way? Thank you. In the principal legislation, Section 15(7), subject to paragraph B, subsection 5 shall not operate to prohibit the continuation of a reproductive technology procedure provided to persons who were the parties to a marriage when gametes were or an embryo was placed in the body of a woman pursuant to the procedure. Paragraph A should not operate to permit any further gametes or further embryo to be placed in the body of that woman pursuant to that procedure. I'd like to give the floor to the DOH to supplement any further information. DOH.
咁其實實務守則
Well, according to the COP, it explains the laws of Hong Kong or any restricted matters. After the start of the procedure, if a husband passes away, the human reproductive technology that has already started could continue. However, before the start of such technologies, if the husband has already passed away, the woman shouldn't start the human reproductive technology. Mr. Edmund Wong, answer your question. Well, please allow me to follow up on it. I believe all of us understand this is in line with laws of Hong Kong. Just now, the administration talked about the COP and the consent form, but I would let Ms. Judy Chen follow up on it. My question is that be it the COP or the consent form, if the COP isn't legally binding or if it is not based on any piece of legislation, can I see it this way? This COP is subject to criticisms. Or may the consent form be revoked? The consent form is a contract. It's a contract between the patient, or put it this way, an individual and a license center. According to contract law, this will be subject to challenges or revocation. At the signing of the contract, do you require any doctor to prove that this contract isn't signed by any mentally incapacitated person? Are there any such requirements, or is it too complicated? Thank you. Who will take this question? Dr. Chen? Is it legally binding, as the principal assistant secretary and the undersecretary said? If one doesn't comply with the code of practice, one wouldn't be able to renew its license. The code of practice helps license centers to comply with the requirements under the law. When one already breaks the law, or when one violates the COP, then the license center has already violated the law. At the signing of a consent form, member just now talked about mental incapacitation. There are doctors in the license center. They will judge whether it is appropriate for a woman to bear a child. The doctor will also tell the patient about the risks involved, and that is advice given to patients. That's why we have a code of practice requiring the signing of a consent form every 2 years, or a patient or an individual will have to be informed of all the risks at the time of the freezing of the eggs. One of the spirits of the ordinance is the medical practitioners working in a center will be able to give appropriate medical advice to the public. Thank you. Ms. Judy Chen. Thank you, Madam Chair. Just now we said that when the procedures had already started, then the procedure could go on. What is the definition of a procedure? When a wed couple is diagnosed as infertile, in theory, when they start storing the embryo, then the procedure has already started. That is my first question. Maybe I let the administration answer my question first. About the definition of the start of a procedure. DOH? Which official will take this question? When the embryo is put inside the body of the mother. What about the extraction of gametes? Is it seen as the start of a procedure? No. So what I said wouldn't exist. Is that correct? Correct. The administration hasn't yet answered my question. Well, if the gametes or embryos need to be sent out of Hong Kong, at present it is allowed. But are the procedures complicated? Just now the Undersecretary told us there are now 26,000 47 are used to create an embryo. Successful cases, a total of 7. But just now you also mentioned the figure of 90. That is those requiring the embryo to be sent outside Hong Kong. As Madam Chair said, there are single women who want to use their gametes. I'd like to know if you identify any increase in the number of gametes being sent out of Hong Kong. And I also would like to know how the consultation exercise will be started. Internally, are you discussing any consultation exercise about single women? Well, simply put, any figures? Thank you. Between 2021 and 2023, in total 90. So in 3 years, 90 were exported to outside Hong Kong. Well, I mean exported out of Hong Kong to overseas jurisdictions. They were taken out of Hong Kong. 90 per 3 years, so averaging 30 per year. 47 every year for embryos. And 30 out of 47, it's not, if we compare 47 and 30, it's not a small figure at all. The figures I have are only for exportation, and after exportation, did they continue with the procedures? We don't have the figures. In the regular review of the COP, did you face this problem squarely, Or when will you start discussing this matter? For single women, if they have frozen their eggs, if I understand correctly, they do so in Hong Kong. But there are also situations in which they choose to export their eggs out of Hong Kong owing to limitations in Hong Kong. Then this may lead to a live birth event out of Hong Kong. So do you mean if there are more live birth events? Well, we don't have any figures in this regard. We will discuss it with the council. Some members already asked this question. Right now, we have a limitation of wedded couple. We did discuss whether we should extend it to single women, but at present, we still comply with the marriage ordinance and the marriage system in Hong Kong. We want to enable members of the public to realize reproductive autonomy, and we also need to take into account medical factors, ethical factors, and the well-being of children. But basically, the Council will review the matters having been raised earlier on. Madam Chair, I have a question. I understand they don't have a good grasp of the situation. They were telling us about the exported gametes between 2020 and 2023, but I do hope that you will look into the situation and have a better grasp of the situation. Thank you, Madam Chair. Well, it's been 1.5 years for our policy discussion. For the third round of the question, I will assign a time limit of 3 minutes. Mr. Edmund Wong, thank you. Just now, the Bureau and the DOH only quoted the ordinance. It's about the requirements when it comes to renewal of licenses. However, my question focuses on patients. When a patient disputes the consent form, what is the legal effect? The Health Bureau and the DOH may not understand fully the crux of the matter. We have the Department of Justice with us. Can I ask the DOJ anything else to add? Thank you. As the Bureau said just now, in the COP, mainly it's about license centers. It doesn't touch upon patients. Just now, members talked about patients, but I'd like to see clarifications. What is your question specifically? Well, this consent form is based on the COP, but there is no law supporting the COP. Then it may collapse easily. At present, divorce, passing away, there are many situations rendering the contract not voidable. One of the instances is mental capacity. We as legislators need to look at this ordinance from a legal perspective. We need to prevent any disputes, legal proceedings, and so on. DOJ? Well, yes, the DH may supplement further information if need be. The code of practice is about the code given to license centers. It doesn't target patients. For documents signed by patients, if they want to they will have to put forward legal arguments. Well, the consent form is standard according to the COP. All of them are standard forms. They are specified forms. Whether it be designated donation or anonymous donation or for one's own use, there are standard consent forms under the COP. Madam Chair, I know I have used up all my time. I'd like to know if the administration will amend the legislation further. Ms. Nick Z. Lam, thank you, Madam Chair. I'd like to ask about the scenario case that is divorce, or as Ms. Judy Chen mentioned, when someone passes away. I'd like to ask about the cutoff, say after a divorce. Just now, in your answer, you focused on the center, the license center. After one files for divorce, recently there's a pop star in Korea. A pop star was pregnant, but the ex-husband was shocked. He didn't know why it would happen. What is the cutoff date of the divorce?
Second question about the patients passing away. Does it mean that at the moment when the patients died, the administrator or the owner of the embryo becomes the license center? What if my will assigns the custody of my embryo to my family members? Say if I'm terminally ill, can I sign a legal document to transfer the embryo to another center or family member or another country? Is that flexibility provided for in the legislation? Now, for marriage or divorce, a couple in marriage, I'm not referring to a couple, I'm talking about a party of the couple. I meant the cutoff date. Now, my team may assist me, but at the moment when the gametes or embryos are stored, at that point, if the couple are still married, that should be fine. But if we are discussing about a divorce, we can still store the embryo. But if the divorce has been officiated, then that's not allowed. Now, if the wife is going to divorce her husband without the husband knowing, procedures are ongoing. It is not official. So I can fertilize an embryo and give birth to a child, and then I can get a slice of the husband's assets. Well, I will defer to my team. That shouldn't be the case. Now, I refer you to the code of practice. There are different consent forms, including the procedures before the storage of gametes. That includes sufficient counseling. Both the husband and the wife have to undergo counseling After that, they will sign the consent form. So the consent form requires the signatures of both the husband and wife to be valid. Now the consent forms obtained should have the signature of both the husband and wife. I have also signed a consent form myself. At the time I stored 4 embryos, I used one to give birth to my son, so there are still 3 embryos in storage. So if the scenario I mentioned so unfortunately arise, then can I do that? Can I fertilize the embryos without the knowledge of my husband? Or do both the husband and wife have to be present? This is a really serious legal matter because it involves money. Now, if I know the patient is going to die, I can have a lawyer sign a document to transfer the embryo to other places. So first of all, I'll congratulate Miss Nixie Lam for successfully giving birth on the first try. So normally speaking, when one egg is fertilized and one live birth has been given, the treatment cycle has completed. So if you want to use the other 3 embryos, you need to sign another consent form, and both the couple has to sign the consent form. So both couples should be involved to avoid the scenario you mentioned. Members, we have spent 1 hour, 35 minutes on the policy debate. So any more questions? If not, let's look at the subsidiary legislations. Let's look at the Human Reproductive Technology Licensing Amendment Regulation 2025 first. Which official will take us through the amendments? Thank you. Please refer to the marked up copy prepared by the Secretariat. So amending the storage period. Under 1E, gametes and embryos cannot exceed the storage period specified in Section 2. Now, having considered the situation, we will allow a gamete or embryo donated under an anonymous donation or designated donation. So that's Section 15 brackets 1. Next, 002. Section 2 brackets 1, a technical amendment. And then Section 2C. The general storage period applicable to gametes following use, that is 10 years, and also the period up to the time when the patient reaches the age of 55 years. We will delete the restriction and simply say that in the case of a designated donation, 2 years, except as otherwise provided by the code. Next page, 03. A technical amendments definition. Consent form and designated donation. Thank you. There are no questions. I'm waiting for members to ask questions. Any questions? Mr. Edmund Wong. Thank you. Page 2, the addition. You are repealing subsection 2 BCD with just C. So that's subsection C. In the case of a designated donation, 2 years, except as otherwise provided by the code. So all subsection B, C, D have been repealed and to be replaced by C. But what about C, boy? Yes, where are subsection boy and D? Miss Lee, thank you. Now, subsection B has been deleted as well. In fact, subsection B will still be available in the legislation, but it will be repealed. So that's the same for subsection D as well. Subsection D will exist, but the contents will be shown as deleted. So B and D will still be there, saying that they are repealed. Has your question been answered? Yes, but I thought you will be deleting B, C, D and just adding an other subsection B. That's my question. Thank you. Now, to elaborate, usually when we delete a paragraph in the law, we would not rearrange the alphabetical order so that the reader can trace back to the history of the law. So the new subsection C, in the case of a designated donation, 2 years, except as otherwise provided by the code. So has the code otherwise provided for any other scenarios? The Department of Health, please. The 2-year storage restriction for public sector service. Now, after 2 years of storage, after a child is birthed, you can also use the remaining embryo to give another live birth during that period. Is there any question regarding the licensing amendments regulation? Let's look at the other one. Human Reproductive Technology Ordinance. Amendment of Schedule 2, Notice 2025. Department of Health, please. Chair. This is a notice amending Schedule 2 of the Ordinance. These are the specified sex-linked genetic diseases. We are deleting some duplicating diseases which have no significant impact on health, and we are adding 2 diseases representing different spectrum of the disease. And also we are integrating some similar diseases, and we have rearranged the diseases according to alphabetical order. Ms. Nixie Lam. Now, Schedule 2, there is a disease called oral facial digital syndrome 1. So there's another one, oral facial digital syndrome type 1. So what are the differences? Doctor? Thank you. So we are amending the disease according to the latest standard. So we are just following the most updated name internationally. If there are more future updates, we will update the name again.
I'm no expert in medicine. I have a question. You are replacing a new Schedule 2. you're replacing the old Schedule 2 with a new Schedule 2. What are the reasons for doing so? Is it simply a change of the names, or are some diseases no longer sex-linked genetic diseases? Can you tell us why? Thank you, Madam Chair. Just now, the Undersecretary touched upon this as well. This table was published in 2007, containing a total of 73 diseases. Now, we have found that some of the diseases are no longer sex-linked genetic diseases. Some diseases are no longer sex-linked, some are duplicated diseases, some have no significant impact on health. That's why experts think that these diseases shouldn't be kept on the list. There are 2 new diseases. They have been added to the list. We now have 58 diseases remaining on the list. Some diseases have been kept, some new diseases have been added. We are simply replacing the old with the new list. Will you review this schedule on a more regular basis? Will you do so more frequently? Do you do so only in passing, or are you going to review it more regularly? The Council on Human Reproductive Technology does so when they find it necessary. There are ONG doctors and there are also medical geneticists. When they find it necessary, they will review the list and make changes. Ms. Nick Zeelam, well, the administration said that there won't be significant impact. I'd like the administration to clarify this point. I believe members of the public who are watching us online would want to know more about this as well. What does no significant impact on health mean? Experts in the working group already said that for G6PD, it's been removed from the list. Although it is a sex-linked genetic disease, there are ways to work around this disease. For example, children may avoid particular type of food. So we no longer keep G6PD on the schedule. Thank you. Just now you cited the example of G6PD. It's been removed from the list. I'm not sure if there are any tests in relation to G6PD at the birth of a child. Some may question why G6PD isn't kept on the list. According to the guidelines given by the Council, when the child has mortality, then we may include these diseases in the list. Otherwise, these may lead to abuse of the mechanism. Just now you cited G6PD deficiency. These tests should be included in the prenatal assessment. In relation to embryos, only when the conditions are so serious as to affect the upbringing of a child. Otherwise, this won't be done. in the laboratory, we don't have to we don't have to conduct any screening tests in relation to the sex of a child. That's why some diseases are no longer on the list. Ms. Connie Lam, well, out of curiosity, I'd like to ask about Schedule 2. There are different genetic disorders. There is a particular type of diseases. I just recently came to notice it. There are only 300,000 babies all around the world suffering from such a diseases. That is epidermolysis bullosa. Is it possible to terminate one's pregnancy when a baby suffers from this disorder? Is this disease, that is epidermolysis bullosa, on the list of sex-linked genetic diseases? Just now we already explained the principle regarding the disorder. You just now mentioned we may have to go back and study this disorder. Afterwards, we'll give you a reply. But under normal circumstances, we reference this list. There are many societies overseas that provide suggestions. We will reference these suggestions. And we will also reference principle, say for minor issues, that is G6PD deficiency. We recommend that it should not be included. For babies suffering from epidermolysis bullosa, they will have to go through different treatments. Say they will have to have their wounds cleansed, and there may be likelihood of infection or complications afterwards. Anything to add? Well, we will have to go back to study this issue, that is butterfly babies. It may have to do with the chromosome of a baby. While the experts were preparing for this list, it was said that this list is actually the last resort. Medical advances are quite advanced. We don't have to necessarily resort to this list. That's why we only keep the most serious diseases on this list. We want to adopt technological means to prevent diseases from being passed on to future generations. Well, in some cases, these diseases could be identified in prenatal assessments. Well, do I need to extend the meeting? Any more questions from members? Well, I'd like to ask legal advisor or administration anything else to add? Regarding butterfly babies, I'm not sure about the technical term of the disorder you just now mentioned. For diseases not sex-linked, they will not be kept on the list. Just now, Ms. Lam is worried about lack of figures or statistics. Just now I talked about 13,000. I mentioned this figure. They have consolidated a total of 27 studies. With flexible arrangements, childbirth will not be encouraged. Well, probably you can keep a close eye on the situation. Legal advisor, have you studied the Chinese and English versions of the subsidiary legislation? Thank you, Madam Chair. We haven't yet identified any issues. There's no inconsistency between the Chinese and the English texts. Thank you. We have completed the scrutiny of these two pieces of subsidiary legislation. Last Wednesday, by way of a resolution, these two pieces of subsidiary legislation, well, the deadline has been put back to the 15th of September. On the 29th of August, a report will be made to the House Committee regarding the deadline for amending the subsidiary legislation. The deadline is the 3rd of September. Members, please take note of the deadline. Well, I believe we don't have to hold another meeting. If need be, we will inform members. There being no other business, meeting adjourned. Thank you, the administration, for joining us.